And so then these things become symbolic, Don, and people fight over stuff.
I think they do, but I have to say, during the course of a case, you hear those sorts of things, but I mean, a lot of times there's so many other balls in the air, valuations and other monetary issues, that at the end of the day, typically that gets resolved in most cases. And I've had judges, and I've even had settlements whereby the decision was made that they flipped the coin and then alternated. You know, one spouse took one thing, the next spouse took the next thing, and they went right down the line, and then what they didn't want, they auctioned off.
The other way that New Jersey judges, I think, first of all, their first instance is when you tell them there's a problem.
Yes.
We don't do dogs and furniture. Yeah. That's a standard line, you know. But then the other option that they'll say is make two lists. One person makes two lists and the other picks one list. So therefore, you're assured that each list is going to be fair. And that's the way it's resolved. And many times when you talked about your first meeting with someone, that would be something we'd discuss, and we'd say, you know, really we have to pay attention to what's extremely important in this case. Then again, you can have somebody who has extraordinary Oriental rug collection or lots of antiques that could have significant value. That's a whole different story. But most people and clients tend to think that their couch, which cost them $5,000 and is now worth probably $200 on the open market, is really something they have to fight about, and they don't realize the amount of depreciation that goes into those items.
Or whatever unbroken bottles remain in the wine cellar.
Yes, well, yeah, then you know, that's another thing that you might have to have valued,
right,
because sometimes it's extensive enough.
We know that most of you are calling about questions about custody, visitation, and divorce tonight. We're going to get to those in just a minute, but before we leave the pet issue, here are a number of factors that you should keep in mind if you want to keep your pet. Your papers, please. Show your spouse, your lawyer, and the court proof that you bought and that you own the pet, that you owned it before your marriage. Also talk to your lawyer and your ex. You might find out that your ex has no interest in the pet and it's yours. Feed, shampoo, walk, and repeat. You're more likely to get ownership of your pet if you can actually prove that you cared for the pet during the marriage. That case just came down just like that in Monroe County today. And yes, kids go better with pets. The person who has a child, who has child custody, probably has a better chance of getting the family pet. So those are just a couple of things to keep in mind. They're not calling it custody, not in New Jersey, not yet. They're not calling it custody, certainly in Pennsylvania, although a judge recently in Maryland did use the C word, as Valerie Jones said in the package, did call it custody. So we're getting, ultimately we're getting pretty close, Don. Sharing, yes. So we're just waiting for Pennsylvania to catch up to New Jersey. Is that a recurring theme in family law practice? I don't want to.
I practice here.
Well, it's certainly not you and the judges, but perhaps it's the legislature. But certainly, lots of dog lovers are going to be at least encouraged by the fact, for example, in Monroe County today. I mean, the judge didn't use the term custody, but he said, you know, this person has put a lot more money into vet bills, feeds the dog, and has spent more time with the dog. So guess what? You get possession of this piece of personal property. So you're still getting to the right decision, if you will. Yeah, even if you can't use the legal terminology that you'd like to use sometime.
Yeah, I think the judge, that case didn't involve a marriage, but I think that it did not involve spouses, but I think the principle was if you can show that you lay a foundation that one person took care of the pet, I think it would be convincing to, whatever you want to call it, to distribute that piece of property to that person.
All right, let's get to some of your emails and then to some of your telephone calls, and then we're just going to, you know, start using our general divorce and custody muscles here, folks. I'm about to end my long-time marriage, says our questioner. My spouse is not working and wants custody and child support. He hasn't worked for 2 years and has drained our finances. I'm now told the court will look at where we are now rather than when he last worked. I expected alimony, and I'm now being faced with a request for child support. I've worked hard for 10 years, but just part-time, and find it hard just to support myself. I desperately want to have my son live with me, but his alliance seems to be with his father. I know that question may be a little all over the place. Name withheld from Turnersville, New Jersey. Where can we get her started, or get him started, Bonnie?
Well, I'm trying to remember all of the facts because there were so many in that question. But the issue of alimony, courts will always look to see a person's ability to earn and ability to support him or herself. So just because someone hasn't worked for 2 years does not mean that a court is going to take that as gospel and go off and running with that. They're going to say, can that person work? What's that person's ability to earn? And look at other factors. So I wouldn't be so rushed to think that this person was just going to get alimony, because I don't know what the finances, but because that person hasn't worked for 2 years, because they do it for women all the time in New Jersey. They say you have the ability to make $30,000, you have the ability to make $35,000, and so that the court would look at what his ability is, what his education is, and what can he do.
Same in Pennsylvania. They look at the courts look at earning capacity, not actual earnings, and they would look to why the person isn't working. I mean, if he's medically disabled, that's one thing. If he's chosen just not to work, court would look at what his earning capacity is, and if it's higher than the spouse that's working, that spouse could obtain alimony. As far as the custody piece, I don't know. I mean, depending on the age of the child, if the child is bonded more with the dad than the mom for whatever the reasons, then I think that the father might have a good argument for custody, but we'd have to know more facts.
Thanks for addressing that question from that gentleman or woman from Turnersville. Let's go to Ellie for a phone call tonight from Easton, PA. Ellie, you're on the American Law Journal. What can we do for you? Do we have Ellie punched in?
Yes.
Don't seem to be reaching her here on the set at the moment. Right now, if you had to pick the hottest topic or the issue that's coming across your desk in repeat fashion, if you will, that you have to tackle, that maybe you didn't have to deal with quite so much 3 or 4 years ago, what would that be?
I think relocations, custody relocations.
They're coming back up again. They're raising their head again.
Yeah, I see a lot of it. People are just more mobile. They have to change jobs. What we see is typically the move is because of employment, or the move might be that a spouse has lived in our area, but then when the marriage dissolves, they need to go back to their family for their support group and those sorts of things. And the other thing that I see a lot of, and I'm not saying I see a lot of this across my desk, but these assisted reproduction issues, frozen embryo contracts, sperm donor contracts, things like that. You're seeing some of that now. Not a daily occurrence, not even necessarily a monthly occurrence, but those sorts of situations are just occurring more.
I think, just to follow up what Don said, that with the relocations, I think you're having more people now, if the non-employed spouse is the one who ends up with the children, and that's the person who wants to move, they may say because of the economy, because of how expensive it is to live here, and I can't get a job here, I need to be back with my family, I need to be some other place because it's economically better for me. So you have some of those reasons being more prevalent now than even before. So some of that, I think we're seeing a little bit more of that. And interestingly enough, in the past 3 months, I've had 3 or 4 prenups, whereas I might have 1 a year normally. So I just found that very interesting, that there have to be a lot more of them coming across my desk. I don't know why. But.
In financial hard times.
Yeah.
Interesting.
Yeah, I've seen a lot more of those too.
And you've seen more of those too.
Yeah.
Dr. DeGeer, as far as marital therapy going on right now, are you seeing more divorce cases coming to your doorstep, especially since the economy went south about a year and a half ago?
I would say it's the opposite. I think I'm seeing more couples who are really wanting to work on their marriage. Maybe if finances were better, they'd be looking to end it, but it's a tough time to end a marriage, so they're trying to make it work.
Interesting. Interesting. And you folks in some ways have found the same thing too, that divorce has kind of lessened there for a while.
Well, the economy is an odd circumstance in matrimonial law, because if you represent a business owner, and there's going to be a divorce, the best time to divorce is when the market's low, because your value is going to be less.
Exactly.
So that's just a fact. If you're the person that wants to end up with the house, then the
It's
values
good.
are low.
Right. Not a good time. Well, it's a good time if you want to get the house. Right. Exactly.
But statistically in New Jersey, there's been a fall off in the last 2 years of approximately 5,000 filings a year. So there has been numerically a change in the amount of filings.
Folks, I promise you we're going to be taking your telephone calls in just a minute. We've just got to work on a technical issue. We're going to be right back with our 3 guests. We're talking divorce, custody, visitation, and what do you do with Fido if you do go through a divorce. More when we return in just a minute.
Happy anniversary, Law Journal. 20 years, a long time, but not so long time. I think your show is a terrific program for everybody in Lehigh Valley and everybody that watches that show. I think they're better individuals, better citizens, and there's certainly much to be gained by watching a Law Journal show, and I highly recommend it, and congratulations.
This week's American Law Journal has been made possible in part by King, Spry, Herman, Freund, and Fall, a long-standing comprehensive practice serving its clients in family law, business, personal injury, and school law matters for over 30 years. Einhorn Harris, a comprehensive New Jersey litigation firm dedicated to its clients and its community for almost 50 years, with the largest family law practice in the state. LJTV Media and Creative Services, providing innovative video solutions for law firms, including video-based online Google advertising campaigns and search engine marketing. LJTV, because you're so much more than a talking head. Go to ljtv.tv. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
Divorce, pets, personal property. What are we really fighting about? Tonight we're taking a look at family law. 3 guests on the set with me tonight. Bonnie Frost from Einhorn, Harris, Asher, Barbarito, and Frost. The name has changed just a little bit over the years, not much. And Bonnie in practice now, we'll just say for a couple of decades, and is really one of the star players in New Jersey when it comes to family law matters. She has headed the State Bar Association's family law section. She's on numerous committees, has taken a number of cases to the very highest courts in the state of New Jersey. Dr. Lisa DeGeer is with us tonight. And Lisa has spent 10 years in private practice, but her practice as a psychologist goes beyond that. She has a marital and family psychology practice, if you will, therapy practice in Pennington, New Jersey. And Don Spry joins us once again with King, Spry, Herman, Freund, and Fall. Over 30 years in practice for Don Spry. And Don, again, has been on this program since we started 20 years ago. So I hope you will forgive me, because we are celebrating the 20 years. But we just have to take a look at some of the video. And Bonnie, this is kind of, do you remember this? Going back to, I think, 1995. Let's take a look.
Okay, but maybe there's been a set-off because in turn the husband owed her alimony, so maybe she's not paying because there's been some cutoff, but there's been some credit back and forth because of some alimony obligation. But my experience, certainly in the recent past, is that men do get custody if it's in the best interest of the children at this point in time. I think that, we have many cases at this point in time where
Has that changed much over the years, Bonnie, since 1995, where, we talked about maybe men getting the short end of the stick in some custody matters? Things have changed since 1995.
I think that judges they really look past that gender issue when they determine custody. I think there was a point in time where they didn't, but I think they really do look past it now.
Right. So we really should see less anger from from men's groups that feel that they're getting the short end of the stick, because there are a number of family law men-oriented family law groups across the country, and certain very prominent here in Pennsylvania, that scream that men still get rooked in family court.
I don't think that's the case so much in New Jersey anymore. I mean, I'm sure there's always the idiosyncrasy with one judge versus another, but as a general rule, I don't think that's the case.
15 years ago, judges probably weren't saying enough, come on, Missy, go out there and get some work.
That's when a lot of it began.
Really?
A lot of it began.
So you were ahead of the trend, or at least you were focusing on a new trend that was starting at the time. Bonnie, it's good to have you here these 15 years later. And Don, of course, we embarrassed you last week, so last time we had you here on the show, so we'll continue to do that. This actually, I think, Andy, this clip is from the very same program, isn't it? 15 years ago, Don Spry commenting on gender bias in family law.
The areas in my experience where it's most likely to occur, if it does, is when you're calculating the support using what's called the earning capacity for the wife. The husband, if he's working at a lower paying job by choice, is generally charged support based upon what his earning capacity is rather than his actual earnings. I've found courts more likely, some courts, some judges, more likely to ascribe that earning capacity to husbands than to wives. And the other area where I worry about it, and it hasn't occurred all the time, but I worry about it where a father is seeking custody of a young child under 7 years of age.
And what happens?
Is
Why are
that
you
same?
worried?
Is that?
Well, I'm concerned.
And is that true today? Do you still worry about that dad seeking custody of a child under 7? Or has that worry been alleviated somewhat by the march of time?
It's been alleviated somewhat. I think it seems to me that the courts, that there's always been this argument that presumptions is something that's a lazy way of deciding a case because you don't have to look at the facts. And I think courts do now are more likely to look at the facts. I know there can be circumstances where you could argue bias, but I don't see it that much. I see that when moms get custody of kids, it's pretty much because of the facts that have been established, not because they're female. Now, I would say that it would be pretty hard for a dad to get, it's a pretty hard argument for a dad to have custody of a child under 6 months old who's breastfeeding. I mean, but those facts wouldn't support it.
Of course not.
So I think the judges look at the facts. I think that the bench now is a younger bench, at least in my experience in a lot of places.
But a kid starting school might go with the dad. It's possible. Whereas 15 years ago when you were doing the program here, it was probably unlikely.
Let's say less likely.
Yeah, okay.
I think now a judge would look at those facts and determine which parent would be the better parent for the best interest of the child.
All right, let's see if we have our telephones up and working here. If our telecommunication devices are working, let's go to Sherry next. I think she's from Bethlehem, Pennsylvania. Sherry, are you with us?
Yes.
All right. What's your question for us, Sherry? Go ahead.
My husband and I ex-husband have joint custody of my 15-year-old son, and he has filed for sole custody. I don't want to give up my son, but would it be worth my while to spend the money to fight for my son?
Well, just hearing the sound of her voice, the first answer I'd have is yes. But Don and then Bonnie, go ahead.
Well, I would say yes.
And then Dr. DeGeer joined us as well, but go ahead, Don.
I mean, some of the circumstances that would be important is what circumstances have changed such that the father no longer feels that the shared custody arrangement is appropriate. I think the father has the burden of showing that there's going to be a modification. There has to be a modification. So unless the father can show that there's changed circumstances, I think you have a good case to maintain the current circumstance.
Sherry, is there what you would see as a definitive change in circumstances?
Well, first he filed for termination of support, and then he filed for sole custody, and everything was fine, and all of a sudden one night my son refused to talk to me, to look at me, to come and be with me.
How old's your son?
15.
15.
Yeah. And Bonnie, at that age, the courts are really starting to listen to kids quite a bit.
Well, the older they are, the more they're going to listen to them, because I think they realize that teenagers can walk with their feet. They'll make their own decisions because they are headstrong at that age. And many times when children do go from one parent to another, after about 2 months they come back. And they understand that. But New Jersey's law is similar to what Don was saying about Pennsylvania. It would be a modification application, and the burden would be for the husband to show there is a substantial change of circumstances